satu lagi kejuruteraan bahasa Sabi.
Hi, am I audible?
Yes. So, the respondent, are you there? Can you hear me?
Hello, am I audible?
Yes, we can hear you. So, may I know who will be the first respondent?
I will be the first respondent.
So, what's your time allocation?
The first speaker would speak for 16 minutes, and the second speaker would speak for 17 minutes.
70 minutes. Okay, thank you. Hello. Good morning, Your Excellency. Can you hear me?
Morning.
Okay. So we'll wait for another judge here.
Yeah. Can I know who's the other judge?
Mr. Ryan.
Oh,
Mr. Ryan Chong.
let's wait for him.
Hello. Good morning, Your Excellencies. Am I audible?
Hi, yes, I can hear you.
Okay. Welcome. We appreciate your presence here today. So, before we begin, we would like to ask you, Excellencies, to determine who will be the president for this round. You can decide among yourselves.
I think Ryan, you can maybe be the president.
Sure, okay. You mean chair this?
Yeah, share the session.
Yeah.
Okay, sure.
Okay. So all the participants can turn on your camera. Yeah. So, with the president elected, let the round commence. I now invite the participants to present their arguments, starting with the applicant. Thank you.
Hi, yes, who's the applicant?
As outing.
I see. Okay, please introduce yourselves and you can begin your submissions once you're ready.
Mr. President, Your Excellencies, may it please the court. My name is Alif Dini, lead counsel, and together with me, Isha Zulkifli, will be representing the applicant, Republic of Azra, in this case. I will submit for 15 minutes for the first issue, while Michael Kosarich Zulkifli will do the second issue for another 15 minutes, and we reserve 5 minutes for rebuttals. Your Excellencies, we submit that Republic of Azra acted in accordance with international law by launching military attacks against United Provinces of Azana and did not pay reparations for the damage suffered based on three reasons. The first reason is the Republic of Azra has exercised the right to self-defense under international law. The second one is the Republic of Azra only targets lawful objects. And the third one is the Republic of Azra is not responsible to pay for the reparations. Your Excellencies, before I continue with our first issue, may I proceed with the statement of fact first?
Yes, please, give us a short statement of the facts.
Okay, much obliged. Your Excellencies, may I please record? This case concerns the escalating conflict between the developed Democratic Republic of Azura and the developing one-party dictatorship of the United Provinces of Rosanna. The conflict ignited on September 1, 2022 when Rosanna introduced a destabilizing element into the regional balance of power, a hypersonic nuclear missile. This development alarmed the Republic of ILSA and international entities due to its potential for massive destruction and the disruption of global security. ILSA, feeling threatened, began considering strategic responses in early October. However, Rosanna continued its aggressive posture, flaunting its nuclear capabilities through various military drills and test launches. In response, and under the principle of self-defense, ILSA launched a preemptive conventional offensive against Rosanna on October 15, 2022. Rosanna's infrastructure suffered immense damage and its military was thrown into disarray. As Rosanna faced defeat, it resorted to the extreme measure of deploying its hypersonic nuclear weapon against ILSA's military command and control center, the Octagon, located in ILSA's capital city of 8 million of inhabitants. The devastation was immense. It claimed hundreds of thousands of lives instantly, injured thousands more, and exposed survivors to harmful radiation. On November 2, 2022, the UN Security Council convened an emergency session condemning Rosanna's nuclear attack and demanding a ceasefire and diplomatic dialogue between the Republic of ILSA and the United Provinces of Rosanna. Your Excellencies, we stand before you today to seek justice and reparation for the unprecedented violation of international law and the immense human suffering it has caused. Your Excellencies, for the first issue, Republic of ILSA is not violating any international law based on the reason that the Republic of ILSA has exercised the right to self-defense under international law. This is a fundamental principle under the Charter of the United Nations, particularly as articulated in Article 51, that every nation possesses the inherent right to self-defense in response to an armed attack. In our case at hand, the Republic of ILSA, while initially launching a preemptive strike, found itself at the receiving end of a highly disproportionate and devastating nuclear strike by the United Provinces of Rosanna. This escalated response resulted in substantial loss of life and extensive damage to critical infrastructure, a clear example of what is defined as an armed attack under Article 51. In response to this act of aggression, the Republic of ILSA has exercised its right to self-defense. This was not a choice made lightly, but was necessitated by the urgent need to protect its territory and its people from further harm. ILSA's initial strike, while a forceful action, was a measure of anticipatory self-defense in response to the imminent threat posed by Rosanna's hypersonic nuclear missile capabilities and their provocative military drills. This falls within the current test, as the necessity of self-defense was instant, overwhelming, and left no choice of means and no moment for deliberation. Moreover, demonstrating full respect for international law, the Republic of ILSA has reported its actions to Security Council immediately after initiating defensive operations, thereby fulfilling its obligations under Article 51. The importance of such reporting was emphasized in the ICJ's judgment in the Congo against Uganda case. In light of these considerations, we respectfully submit to this esteemed court that the Republic of ILSA has acted within its legal rights under international law. Specifically, it exercised its right to self-defense as provided for under Article 51 of the United Nations Charter in response to the armed attack it suffered.
Council, can I just ask you, I want to see clarification on, when you say, when we talk about self-defense, right? Just the mere fact of Roxana developing the system, would that have posed an enough of a threat for you to exercise your right to self-defense? What's your response to that?
To answer your question, Your Honor, yes, in our case, the United Provinces of Rosanna's development and testing of hypersonic nuclear missiles, coupled with the explicit threats and provocative military drills, really pose an immediate threat to our country. And this created an immediate and overwhelming threat to the Republic of ILSA. So therefore, ILSA exercised its inherent right to self-defense by launching a preemptive strike to neutralize this imminent threat.
All right, proceed.
Okay. Much obliged. Allow me to now direct your attention to our second point, that is the lawful targeting of objects by the Republic of Azura during the unfortunate conflict. In accordance with Article 52, Clause 2 of the Additional Protocol 1 to the Geneva Conventions, attacks during an armed conflict must be strictly limited to military objectives. As defined, these military objectives can be referred to their nature, location, purpose, or used to make an effective contribution to military action. In the midst of this conflict, the Republic of Azura, being respectful of international law, targeted its actions toward critical infrastructure, power plants, transportation networks, and command control centers. As evidenced on page 11, paragraph 22 of our Moot problem, all these targets were chosen meticulously, aimed at disabling the United Provinces of Lausanne's military potential while ensuring minimum harm to the civilian population, to incapacitate military capabilities while leaving civilian life untouched. Your Excellencies, I draw your attention to the case of the legality of the threat or use of nuclear weapons, where it was affirmed that the principles of proportionality are integral parts of the international customary law. It is important to distinguish between the peaceful use of nuclear technology and the development of nuclear weapons. Even though it is recognized under NPT, but it does not extend to the creation of weapons in mass destruction. For instance, United Nations Security Council has imposed several rounds of sanctions on North Korea due to repeated testing of nuclear weapons and ballistic missiles. In light of this, the Republic of Azura's actions have been within the bounds of legality and necessity undertaken to protect its sovereignty and its people. In summary, we respectfully submit that the Republic of Azura has adhered to international law, targeting only lawful subjects and maintaining a strict adherence to principles of proportionality. Moving on to our last point, the Republic of Azura submits that it is not liable to pay reparations. As stipulated in Article 31 of the Articles on Responsibility of States for Internationally Wrongful Acts, reparations are due when there is a breach of an international obligation. Azura acted within its rights under Article 51 of the UN Charter in self-defense to an armed attack by Rosanna. This fact alone negates any assertion of wrongdoing on Azura's part and thereby removes any legal foundation for reparations. Furthermore, the causation, as per Article 31 of the aforementioned articles, between Azura's actions and the alleged damage is not clear. The burden of proof lies with Rosanna to demonstrate this causal link, which it has failed to do. The Corfu Channel case established the necessity of such proof. In this case, the United Kingdom alleged that Albania had laid mines in the Corfu Channel, or had at least known about the mines that had been laid by a third party. The mines had damaged British naval vessels, leading to loss of life and property. In the ICJ stated that it is the duty of the party making the claim to produce the requisite evidence. This is a standard principle of law that the party who makes an assertion it is responsible for providing evidence to support that assertion. Therefore, the UK was required to prove that Albania had knowledge of the mines in Corfu Channel. The ICJ, after reviewing the evidence, found that the UK had met its burden of proof in establishing that Albania had knowledge of the mines. Therefore, without clear evidence of causation, there is no legal basis for Azura's obligation to pay for reparations. Therefore, we submit that the Republic of Azura acted in accordance with international law by launching military attacks against United Provinces of Lausanne and need not pay reparations for the damage. If there are no further questions by the floor, I will end my first submission here, and my co-counsel shall proceed with the second issue.
Sure. I have no questions on my end in my learned friend has any.
No.
Your Excellencies, may I proceed with my submission?
Yes, please proceed.
May it please the court. Mr. President, Your Excellencies, my name is Rishal Zulkifli. As the co-counsel, we'll continue with the second issue in which we submit that First, it is
Counsel,
wrongful.
could you turn on your camera, please?
I already turned on my camera. Am I visible?
I can see her, Ryan. Can you see
Oh,
her? Yeah.
okay, got it. There's another window. Okay, please proceed.
Thank you so much. May it please the court, Mr. President, Your Excellency. So my name is Risha Zulkifli. As the co-counsel, we will continue with the second issue in which we submit that the United Provinces of Roxana violated international law in targeting Octagon with its hypersonic nuclear missile and must pay reparation to Republic of Azura for the damage suffered based on three contentions. First, it is wrongful to use nuclear weapons. Second, Octagon is not considered as military object. Third, Roxana is responsible to restore the damage that suffered by Republic of Azura. Mr. President, Your Excellency, our first intention is regarding the environmental consequences of the nuclear weapon launch. Article 35 and Article 55 of the Additional Protocol 1 to the Geneva Convention explicitly prohibit methods of warfare that are intended to cause severe damage to the natural environment. The launch of the hypersonic nuclear missile by Roxana, which released large amounts of pollutants into the atmosphere, falls under this prohibition. Thus, we submit that Roxana has violated its international legal obligation, especially those related to the prohibition of causing widespread and severe environmental damage during the warfare. In light of this consideration, we respectfully urge the court to find that the United Provinces of Roxana, in violation of its obligation under international humanitarian law for causing severe environmental damage and for breaching the principles of distinction. Mr. President, Your Excellencies, we now turn to the second contention, which is we maintain that Octagon is not considered as military object and that the United Provinces of Roxana's attack on it contravenes international law. We first turn to the definition and status of Octagon. Article 52, Clause 2 of Additional Protocol 1 to the Geneva Convention of 1949 provides the definition of military objective. Roxana attacked Octagon with a hypersonic nuclear missile, asserting that it was a military object. However, there's no indication that Octagon was being used for any military purpose or that it offered a definite military advantage to Azura. This echoes the jurisprudence of the case of prosecutor against Distotade, which clarified certain aspects of what we can be considered as military objects. Article 85 of Additional Protocol 1 considers making the civilian population or individual civilians not taking part in hostilities of the object of an attack a grave breach of the protocol. In this case, Octagon contributed nothing to the military action. Given this consideration, we respectfully request the court to find that the United Provinces of Roxana breached the international humanitarian law by attacking the Octagon, which is not a military object, causing civilian casualties and resulting in a grave breach of the Geneva Convention. Mr. President, Your Excellencies, as for our last contention, we wish to argue that United Provinces of Roxana is under a duty to restore the damage that has been suffered by Republic of Azura. We start by referring to the fundamental principle of the international law, which posits that a responsible state has a duty to provide complete compensation for the harm resulting from the internationally wrongful act. This is stated in Article 31 of the Articles on the Responsibility of States for the Internationally Wrongful Act 2001, which provides that the responsible state is under an obligation to make full reparation for the injury caused by the Internationally Wrongful Act. The significance of this principle has been underscored in the landmark cases such as case of Chozo factory. In this case, the ECIJ held that the obligation of a state to make full reparation for an internationally wrongful act was integral to a fulfillment of the international responsibility. In light of this consideration, we respectfully urge the court to find that Roxana is obliged to provide full reparation to Azra for the harm caused by its internationally wrongful act. Therefore, we submit that United Provinces of Roxana violated international law in targeting Octagon with its hypersonic nuclear missile and must pay reparation to the Republic of Azra for the damage suffered. Thank you for your attention, Mr. President, Your Excellencies. I stand and ready to answer any queries you may have.
Council, I just want to ask you, your first point talks about how, the use of nuclear weapons was excessive. And of course, according to your submission, illegal. In light of the attacks by your client against Roxana, what would have been your view to be something which is proportionate to the attack? Was Roxana just supposed to not do anything because they were attacked, right? That's not something in dispute. So maybe you can enlighten this panel on what you thought would have been proportionate instead, or were your client or was Roxana was just not supposed to do anything and stood by while while its infrastructure and all sorts was attacked?
Your Excellencies, correct me if I'm wrong. Your question means that you want my or our opinion regarding this case?
Yes, your views. Well, what would have been proportionate?
Your Excellencies, in the light of the consideration, Azura attacked the military base of Roxana only to paralyze their military advancement, and there's no casualties reported in the Moot problem. In our opinion, it is proportionate for us, Azura, to only seek for discussion and for a reconciliation between two parties.
So my question would be then, would so what you did was fine, what your client did was fine, and Roxana was not supposed to retaliate at all?
Yes, Your Excellency.
Okay. All right.
Okay, I think we can proceed with the respondents. I have no questions on my end.
Thank you.
Excuse me, am I audible?
Yes, yes, you are.
Okay, thank you. Good morning, Madam and Mr. President, Your Excellencies, may it please the court. My name is Afiq Ahmad Hanif, and I have the honor to appear on behalf of the Republic of Roxana, the respondent in today's proceedings. I will speak for 16 minutes, and my co-agent, Ms. Johanna, will speak for 17 minutes. And with your permission, we reserve 2 minutes for short rebuttal. Your Excellencies, over the course of the next 16 minutes, I will be submitting that Republic of Azura violated international law by launching military attacks against United Provinces of Roxana and must pay reparations for the damage suffered. And my co-agent will be submitting our second submission that United Provinces of Roxana acted in accordance with international law in targeting Octagon with its hypersonic nuclear missile and did not pay reparations to Republic of Azura for the damage suffered. If this court doesn't have a preliminary inquiry, may I proceed to my first submission?
Yes, yes, please proceed.
Thank you, Your Excellency. The military attack conducted by Republic of Azura occurred in Roxana territory on 15 October 2022 and constituted a breach of international law and principle of international law. Your Excellencies, entering our first submission, we submit that, firstly, Azura military attack violates international law by launching an attack towards Roxana. And secondly, Azura is obligated to compensate Roxana for impacts. In the first issue, we submit that, first, Azura committed an act of aggression. Second, in any event, International law does not recognize preemptive self-defense. And lastly, the possession of nuclear weapons is not prohibited under international law. Entering our first argument that Azura military attack violates international law by launching an attack towards Roxana. Here we argue that Azura committed an act of aggression. The attack conducted by Azura is an act of aggression, whereas under customary international law, the threshold for this action has stated explicitly. To fulfill the requirement of an act of aggression, Azura has breached the principle of non-use of force and violates the sovereignty of another territory. Moving into our first argument, that Azura has breached the principle of non-use of force. The attack launched by Azura on Roxana's territory is a clear violation of Article 2, Paragraph 4 of the Charter regarding the prohibition of the use of force against another state territory. Moreover, the prohibition of non-use of force is also recognized as a peremptory norm and customary international law. Republic of Azura launched a conventional attack against United Provinces of Roxana, utilizing its land, air, and naval forces in a coordinated assault. Thus, the attack was a breach of Roxana's territorial integrity and the principle of non-use of force. Moving to our second sub-argument, Azura's military attack violates the sovereignty of Roxana. The concept of sovereignty comprises the possession of supreme authority of a state, including the power of regulating its international affairs without foreign dictation. The decision of ICJ on Corfu Channel case emphasizes that it is fundamental for states to respect territorial integrity, territorial sovereignty in the matter of international relations. The statement made by United Provinces of Roxana's Ministry of Foreign Affairs that the attack was a blatant violation of international law and their sovereignty. Based on the Article 2, Paragraph 4 of the Charter, it is clear that the breach of a state's territorial integrity is a violation of sovereignty. Moving to our second argument, in any event, international law does not recognize preemptive self-defense. Under international law, preemptive self-defense is not recognized since Article 51 of the Charter only recognized individual or collective self-defense. But in the present case, the Republic of Azura launched the attack under the doctrine of preemptive self-defense, which has never been explicitly regulated in the Charter. Furthermore, the Republic of Azura didn't fulfill the requirements of self-defense, which is the military attack is not proportionate and the attack is not necessary. The first threshold that the military attack is not proper. Yes, Your Excellency.
I was going to ask, the act of your client or the respondents rather in developing this hypersonic missile and the various, press conferences or press statements that was issued by Republic Azura stating their concerns, would that have constituted, and you continuing, the respondents continued to develop the hypersonic missile, would that constitute an act of aggression on the respondent side, necessitating a response by the applicant?
Your Excellency, it is clear that the development of our weapon is to assert our sovereignty in the region, and the diplomatic approach that the applicant state conducted cannot resolve what they are trying to achieve here. Therefore, we still continue our development regarding our weaponry program, which is the nuclear weapon itself. And if I may, I will explain later our statement, Your Excellency.
All right, proceed.
Thank you. As we mentioned before, that the threshold of proportionate, the military attack is not proportionate. The attack launched by Republic of Azura is not proportionate since there was a loss of civilian life and the well-being of United Provinces of Roxana's citizens. It is stated in Article 51 Geneva Convention, Additional Protocol 1, that civilians must be kept away from the danger of military operations. Thus, the attack violated international law and didn't fulfill the proportionate requirement. The second threshold, the military attack is not necessary. The attack is not necessary since there is no armed attack prior. In the Nicaragua case, the requirement of necessary is well established that only if an armed attack occurs is it necessary to respond to it. Hence, the military attack launched by Republic of Azura is unnecessary. Moving to our third argument, the possession of nuclear weapons is not prohibited under international law. The hypersonic nuclear missile under the possession of United Provinces of Roxana is not a violation of international law, since the Lotus Principle allows for states to exercise their jurisdiction and their sovereignty if there is no explicit international legal framework that prohibits to do so. The legality of nuclear weapons is also stated in the advisory opinion of legality of the threat or use of nuclear weapons, where there is no universal prohibition of the threat or use of nuclear weapons as such. Thus, absent such prohibitory rule, states have the right to use nuclear weapons. Moving to our second issue, that Azura is obligated to compensate Roxana for the impacts. It was described that the military attack carried out by Azura, resulting in widespread devastation and loss of life throughout the United Provinces of Roxana, is a breach of international law. Regarding this problem, the obligation of reparation is formulated in Article 31 of RCWA as the immediate corollary of a state's responsibility. The obligation to make full reparation is the general obligation of the responsible state consequent upon the commission of an internationally wrongful act. Under this reason, Roxana respectfully asked the court to declare that Azura is entitled to obtain compensation for all the damages caused by Azura. To summarize our argument, we stated that Azura's military attack against Roxana has breached the international law, which resulted in infrastructure destruction and loss of life. Azura's claim for a self-defense is unlawful since there is no armed attack occurred before. Therefore, Azura must pay the reparation for the damages. Unless your excellencies have a future questions, this concluded our argument. May it please the court.
Yes, I do have a question. So, Counsel, you were submitting earlier that it's not self-defense because the military attack is not proportionate. May I know how you define this proportionality? Where is the threshold in which the proportionality shall be?
Your Excellency, the threshold for proportionality and attack is stated in Rule 14 of customary international humanitarian law, and it is also stated in the Article 52, Paragraph 2 of the Geneva Convention Additional Protocol 1, that a military object refers to objects which, due to their nature, location, purpose, or use, make an effective contribution to military action and offer a definite military advantage, while the attack launched by Azura caused a loss of civilian life, Your Excellency.
I see. Okay. Is there anything else, Counsel?
Your
Or will you
Excellency,
be-
this concluded our argument.
Okay, we can proceed to the next.
Excuse me, Your Excellencies, am I audible?
Yes,
Yes.
you are.
Good morning, Mr. President, Your Excellencies, may it please the court. My name is Johanna, and I am the co-agent appearing on behalf of United Provinces of Roxana. As introduced by the first agent, I will be dealing with the second submissions in the next 17 minutes. I have the honor to address respondents' final submissions concerning United Provinces of Roxana acted in accordance with international law in targeting Octagon with its hypersonic nuclear missile and did not need to pay reparation to the Republic of Azura for the damage suffered. If this court has no preliminary inquiry, we would like to continue to our respondent submissions.
Yes, please proceed.
Thank you, Your Excellencies. On 29 October 2022, Roxana launched a military attack against Azura's military command and control center. Roxana exercised the right of self-defense under Article 51 of United Nations Charter, which gives an inherent
Oh, I think it's frozen.
Yeah.
Believe maybe you can contact the respondents to say that she's frozen. Probably not aware.
Okay, I will
rights of
contact.
state in response when armed attack. In light of this matter, there
Council?
excuse me, am I audible now?
Yes, but you
Yes.
broke off just now. So maybe you have to repeat what you said in the last 30 seconds.
Shall I repeat from the start?
Mm, mm.
I think you should, yes, please.
Okay. Thank you, Your Excellency. Good morning, Mr. President, Your Excellencies, may it please the court. My name is Johanna, and I am the co-agent appearing on behalf of United Provinces of Roxana. As introduced by the first agent, I will be dealing with the second submissions in the next 17 minutes. I have the honor to address respondents' final submissions concerning United Provinces of Roxana acted in accordance with international law in targeting Octagon with its hypersonic nuclear missile and did not need to pay reparation to the Republic of Azura for the damage suffered. If this court has no preliminary inquiry, we would like to continue to our respondent submissions.
Yes, please proceed.
Thank you, Your Excellency. On 29 October 2022, Roxana launched a military attack against Azura's military command and control center. Roxana exercised the right of self-defense under Article 51 of UN Charter, which gives an inherent right of state in response when armed attack occur. In light of these matters, there are three questions that need to be exercised by this court. Firstly, Roxana's attack in accordance with international law. Secondly, the attacks are in accordance with IHL. And lastly, in any event, Roxana did not have an obligation to pay reparation. Your Excellencies, moving to our first major argument, here we submit that Roxana's attack in accordance with international law because the attack in Octagon constitutes as a self-defense. In Nicaragua, to consider an attack as a self-defense, it must fulfill that there is an armed attack occur, the necessity, proportionality, and in any event, the attack must be directed against legitimate military targets. Turning to our first threshold, here we submit that there is an armed attack occur. Article 51 of the UN Charter requires if there is an armed attack occur. In Congo, the court did not justify Uganda's self-defense due to there is no armed attack occurs. The court also refers to the Article 31 of Vienna Convention on the Law of Treaties that treaty must be interpreted with the ordinary meaning. Similarly, since the Charter explicitly stated that there must be an armed attack occur, Roxana's attack against Azura is justifiable due to in response of Azura's military attack in Roxana's territory. Thus, Roxana's attack was held in response to Azura's attack. Secondly, the attack has fulfilled the necessity. In Nicaragua, to determine the elements of necessity, the court refers to the military attack that is needed to respond to the attack. In the present case, Roxana has even twice attacking Azura has even twice attacking Roxana. Through that, Roxana needs to respond to the attack. Since it threatens Roxana's sovereignty, thus Roxana has fulfilled the necessity. Thirdly, targeting the Octagon has fulfilled the proportionality. In considering the principle of proportionality, the court in Nicaragua military and paramilitary adopted criteria and nature of the target of the use of in the term of self-defense, which refers to a legitimate target, and it must be shown that it had a military purpose. Here, Roxana's act of self-defense was proportionate because it is only directed towards Octagon. Hence, the attack in Octagon has fulfilled the proportionality principle. And additionally, Octagon considered as a legitimate military objectives. In Article 52, Paragraph 2, military targets are the object by its nature, purpose, and use that make an effective contribution to military attack and over a definite military action. In the present case, Octagon, by its purpose, used as a military command and give effective contribution to Azura military action. Therefore, Octagon was considered as a legitimate military target. Moving forward for our second major argument, here we submit that Roxana's attacks are in accordance with IHL. In the armed conflict, the parties must act in accordance with the international humanitarian law. Here, since Azura has attacked Roxana's territory, thus the IHL is a play. In response to Azura's military attack, Roxana has acted in accordance with IHL. Since the attack has fulfilled the IHL principle, and in any event, the launch of nuclear missile is lawful. Turning to our first sub-argument, here we submit that the attacks are in accordance with the principle under IHL. There are three basic principles under IHL that must be fulfilled in attacking the target, which are the target constitutes as a military objectives, apply the principle of distinction, and lastly, the attack was consistent with the principle of humanity. Turning to our first threshold, here we submit that Octagon is a military objectives. Any civilian object used for a military objective loses its civilian character and qualifies as a military objective. Article 52, Paragraph 2 of Additional Protocol 1 provides that attack shall be limited strictly to military objectives. The object targeted should be directly used by the enemy forces and its destruction will give definite military advantage. Here, Octagon was used by Azura for their military efforts, such as overseeing and directing the entire armed forces. Therefore, Octagon is a military objective. Secondly, the launching of nuclear missile was applied the principle of distinction. To determine that the attack is consistent with the principle of distinction, in nuclear weapon adversary opinion, the court refers that the object attack must not be directed against civilian. In Nicaragua, United States of America conducted a military attack through military troops and directly attacking the civilian by shooting. Here, Roxana's attack did not directed against civilian and only directed against Octagon. Thus, the launching of nuclear missile was applied the principle of distinction. Moving to our second sub-argument, here we submit that in any event, the launch of nuclear missile is lawful because there is no prohibition in launching nuclear missile. In nuclear weapon adversary opinion, the court stated that there is no prohibition of using the nuclear missile. However, the attack must fulfill the proportionality in attacks. In any event, the casualties justified as a collateral damage. Turning to our first threshold, here we submit that the attacks has fulfilled the element of proportionality in attacks. Proportionality of an attack requires the balance between the destructive effect and undesirable damage. Under IHL, states are prohibited to launch an attack if the damage anticipated to the civilian would be excessive compared to the military advantage pursued. Here, Roxana has announced the launch of the nuclear missile, and this is proof when Azura activated the missile defense. Concluding that the damage of the attack will be proportional, therefore the attacks were proportional. Turning to our second threshold, here we submit that the civilian casualties justified as a collateral damage. In international law, if the attacks occur by the knowledge that such attack will cause incidental loss of life or injury is forbidden, but launch an attack that had no intention of causing harm to the citizens may be permissible. To prevent disproportionate attacks, it must be determined that there were unintentional attacks causing injury to civilians. Here, Roxana's attack only intentionally directed towards the octagon and did not directed against the civilian population. Thus, the civilian casualties justified as a collateral damage. Moving to our last major argument, here we submit that in any event, Roxana is not obligated to pay any compensation to Azura because Roxana's attack was not internationally wrongful act. A state is under the obligation to make compensation for the injury caused by an international wrongful act. Here, Roxana's attack was not international wrongful act. Therefore, Roxana is not obligated to pay the compensation. In any event, if this court finds that there is a wrongfulness, he will submit that Roxana did not have any obligation to pay the reparations since under Article 21 of the RCWA, the wrongfulness of an act of state is precluded if the act constitutes a lawful measure of self-defense under the Charter. To conclude our submissions, we submit that United Provinces of Roxana acted in accordance with international law in targeting Octagon with its hypersonic nuclear missile and did not have any obligation to pay reparation to the Republic of Azura for the damage suffered. Unless this court have any further question, thank you. May it please the court.
Okay, I have no further questions on my end. Miss ILSA?
No, no questions on my end.
Okay, I think we can proceed with the rebuttal by the applicant.
Much obliged. Mr. President, Your Excellencies, I'm Risha Zulkifli as the co-counsel. We submit the rebuttals for the part of Azura. Here we submit three reasons or three rebuttals on our side, which is the first one. We refuse the act of aggression by Azura. Second, the attack of Azura is necessary due to the fact that Roxana's development is considered as armed attack. The third one is the doctrine of self-defense by Roxana. And the last one is Azura is not a military object. Hence, we will submit 4 rebuttals in total. The first one is we refuse that act of aggression by Azura. According to the Article 51 of the United Nations Charter, the right of self-defense as recognized in the Article 51 allows a state to take necessary measures to defend itself when faced with an armed attack or imminent threat. In the case of Azura and Roxana, Azura has suffered a huge loss compared to Roxana. In Moot problem, page 16, paragraph 17, Roxana has caused the damages in Azura's part, which is 8 million of casualties reported in the Moot problem. Not only that, according to the clarification question number 4, the hypersonic nuclear missile can cause air pollution. During the missile launch, the rocket exhaust would release large amounts of pollutants, including nitrogen oxide, carbon monoxide, and sulfur dioxide into the atmosphere. This obeys the definition of proportionality under the United Nations Charter of Article 51 of the Doctrine of Self-Defense. Mr. President and Your Excellencies, we move to the second rebuttal, which is the attack of Azura is necessary due to the fact that Roxana's development is considered as an armed attack. From the part of respondent, they mentioned about the Nicaragua against the United States 1986. That in that case, armed attack is defined as the one with imminent threat. However, in this case, International Court of Justice has further elaboration on the definition of armed attack. In the definition by the ICJ, it is elaborated on the concept of armed attack and clarified that it concludes not only armed action, but also the sending by a state of armed bands, groups, irregular, or machinery to carry out armed force against another state of such gravity as to amount to the listed earlier. For the Republic of Azura, these principles can be applied to the context of Roxana's threat and nuclear capabilities. Even though Roxana did not physically invade Azura, the development of testing of nuclear hypersonic missiles coupled with explicit threats towards Azura can be construed as an imminent armed attack, triggering Azura's right to self-defense under this international law. Mr. President, Your Excellency, we turn to the third rebuttal, which is under the self-defense of the issue where proportionality under the doctrine of self-defense. According to the Moot problem, page 11, paragraph 20, which stated that Azura only utilized its air, land, and naval forces in order to paralyze their development of nuclear hypersonic missiles. However, in Moot problem, page 16, paragraph 17, Roxana attacked Azura, causes and threatening the civilian there, which consists of 8 million of civilians living in Octagon. As supported in the clarification question 4, which stated that the hypersonic nuclear missile can cause a large amount of pollutants and will cause a huge damage to Azura. Additionally, Roxana development of nuclear weapon has violated Article 2 of the Non-Proliferation Nuclear Weapon. Therefore, we submit that Roxana has violated the international humanitarian law. The last rebuttals, we submit that Azura Octagon is not a military objective. Your Excellencies, Mr. President, the Octagon as described in this case is indeed a structure of a significant value. However, in this case, Octagon is lived by 8 million of citizens. Therefore, Octagon is not considered as a military object. That's the end of our rebuttals. To conclude, we submit 4 rebuttals, which is the first one. We refuse the act of aggression by Azura. Second, attack of Azura is necessary. The third one is we refuse the doctrine of self-defense for the part of Roxana. And the last one is Azura's Octagon is not a military object. Thank you for your attention. We end our rebuttal. Thank you.
Okay. The respondent, please. Your rebuttal.
Your Excellencies, thank you so much. My name is Afik Ahmad Hanif, representing the respondent state in today's proceeding. Here we submit 3 rebuttals. First, under any circumstances, the preemptive self-defense is not recognized in international law. Thus, the applicant state is using Article 51 of the Charter, where it is explicitly stated in the article there is only 2 types of self-defense, which is the individual self-defense and collective self-defense. It is furthermore, the applicant state also stated that it is necessary to take a measure when it comes to a right for their self-defense. It is right, but the applicant state did not fulfill the threshold that are in the article. First threshold are there should be an armed attack prior to the attack, where in this case, there is an absence of armed attack prior to their self-defense. And then secondly, the threshold for self-defense, it is to report to the United Nations Security Council, whereas in this case, the Azura didn't report anything regarding their attack to the United Nations Security Council. And then in the Article 21 of RCWA, it is only right for them to exercise their self-defense if it is lawful and in conformity with the Charter, whereas in the Charter, there is no explicitly stated that they recognize the preemptive self-defense, which the applicant state exercised on Roxana. Secondly, there is no clear threat that our nuclear weapon possess. First, in the Moot problem, it is stated that our nuclear weapon is purely to assert our sovereignty as the lead military country in the region. And then secondly, and then secondly, in the paragraph 29 of the fact, it is stated that Roxana is in the brink of collapse with much of its infrastructure destroyed and its armed forces in disarray. Therefore, our attack on the applicant state is our last resort using our nuclear weapons. And then lastly, the applicant state invoked that we violate the non-proliferation treaty, whereas it is also stated in the facts that we are not a part of the NPT treaty. We are not ratifying that treaty. And then the octagon is clearly a military object, since it gives us a definite military advantage, as it is also stated in the facts that it is to overseeing and directed their armed forces. This concluded our short rebuttal session. Thank you so much, Your Excellency. May it please the court.
Thank you, Council. I think we can conclude at that end. Puan Hanja, anything to add?
I think bailiff. I mean, we can get to scoring and come back.
Okay, Your Excellencies, that concludes the round. We will now adjourn to the deliberation room for further proceedings. So Ramita, can you transfer the participants to the breakout room? Thank you. Have you transferred them?
Yeah, I think they're still in here.
Yeah.
I already opened the group. Can y'all enter?
No,
The
no.
participants?
You need to assign the participants. Okay. Then, so Your Excellencies, you have 15 to 20 minutes to complete the score sheets. Thank
Okay.
you.
Okay, and after that, we come back here for the feedback session. Is that right?
Yeah.
Okay.
You can email the score sheets to the competition office. Do you have the email?
Yes, I think it's
Yep, it's given in one of the emails.
yeah.
It's basically competition union. Okay.
Yep.
I'll just I'll just respond to the email where they send the score sheet, clarification, moot problem, program schedule, right?
Yeah, sure.
Okay. And I'll just rename the trail as score sheet semifinal round. Okay.
So we will reconvene in 15 minutes. Is that so?
That's all. We will come back after 20 minutes.
All right. Okay.
Thank you,
Thank you.
Excellencies.
My hair. I don't know, my hair. I just
Hi, Ramita and Umasri. Are you there?
Yes.
Hi, could I get the first applicants and the second applicants' names, please?
Yeah, sure. Should I WhatsApp you or
I think you can just say it out
okay?
here and I'll just write it in.
I'll
So the,
I've just like followed whatever on the screen, but they didn't actually state it specifically just now. They use short names, so
Yeah.
I
yeah.
hope that's okay. Yeah.
So for the first applicant is Alif Dini,
Alif Dini. Okay.
and the second applicant is Risha.
Risha. Okay. Okay. The first respondent and the second respondent, please.
The first respondent is Afiq,
Ah, okay.
and the second respondent Johanna.
Johanna. Okay. Thank you very much. I'll email it over now.
Okay, thank you.
Hi, everybody. Are we coming back to give the feedback to the students?
Yeah, sure.
Yes, I'm ready.
Yeah.
So we can start the feedback session. So Ramita, can you transfer them here? Okay. Thank you.
Ryan, you want to start?
Yes, I can. Hold on, yeah. Is everybody in? Sorry, I'm not seeing anybody on my screen. That's the problem.
Yes, everybody's here.
We see you, Ryan. So I don't know whether it's the settings. Mm.
Yeah, maybe it's my settings. It's okay. I'll just proceed with the feedback first. So I'm not going to pinpoint anybody, but rather I'll give a more generic feedback that can be used for everybody. So I think mainly everything was great, but first and foremost, I think everybody should speak slower, a little slower, and with more clarity. And remember when you are submitting, do remember to signpost the tribunal. What I mean by signposting is when the submissions were going on just now, it was just a flow of submissions. It was just submissions without any stop, without signposting the tribunal as to what what the next topic was, what the main submissions of the topic was, but rather it was just a very lengthy and quick submission, uh, and it was just a flow. So I would have liked to see a bit more signposting in the sense that if you're moving on to a new topic, a new area, a new submission, remember to alert the tribunal to the same. Let the tribunal know that you are going into the next part of your submission and briefly what that submission is and be a bit more clear on that. I would have also liked to have heard how some of the authorities applied to the facts of the case. Um, I do remember hearing like for the case of Nicaragua, I believe application of the facts of that case was made to the facts of our current mood problem, which is great. But I think generally when we cite authorities, cases, and conventions and whatnot, maybe give a brief description of what the case is about and how it would apply to the mood problem. Because when I was listening to the oral submissions just now, cases were mentioned, authorities were mentioned, some conventions were mentioned, but I'm not too sure how it gels into the overall facts of the case. So I think some application would help. And remember not to read off the memoir or read off a script, because I think it can be quite obvious when you're just reading off the screen or reading off the script. It's okay to improvise a little. It's okay to elaborate on your memoir orally. And I think in practice, I think tribunals and judges would much prefer that as well. I think generally for all the speakers today, posture and eye contact was good. But just remember to speak a little bit slower with more precision and clarity. And be concise. I think there's no necessity to be repetitive. So earlier when the submissions were ongoing, I did realize that it was a bit repetitive in the sense that you kept re-emphasizing your point over and over again. But just be concise and clear, and I think that's all that's necessary, really. I think that's all for my generic feedback. I'll pass the floor over to Puan Izzah Hanjak.
Thanks, Ryan. Just a bit of general feedback as well. I think insofar as spacing is concerned, some were a bit fast, some were okay. It's just that the clarity of it sometimes I couldn't catch what you were saying. And that partly due to perhaps the pacing and partly due because, you know, you were reading. The other thing is if you are reading, if you stop mid-sentence because you lost where you were reading at, it's sort of like obvious, right? So I would advise you to, I mean, it's good to have points for submission. So I'm fine with that. I mean, that's what I do myself. It's just that maybe you have points and you have sub-points and you read off of that. So it becomes more natural. I don't know how, I mean, for some of the other competitions that I've judged, if you're referring to something, they allow for you to share screen so that we see what it is that you're referring to. So I don't think even in this competition, there's an impediment for you to do that. In fact, it will be really helpful. So I'm not sure. But if that's the case, then you can do that because that's what we do. In practice, we refer to the documents because if not, you don't get our attention because I don't know what it is. You know, you're reading off something, I don't know what it is, right? So that maybe my attention span or Ryan's attention span becomes shorter and shorter. A lot of your skill when it comes to speaking, I only saw in rebuttals because you were reading before. So whether you can submit or not, I only saw that in rebuttal. So you do have that talent and that skill set. It's just that you're bound by the scripts that you have prepared, you know. And the thing about scripts is that if you go off script, you suddenly panic and you forget everything that it is that you want to say, and that's quite and I know that because I've done it before. So please do not repeat my mistakes. The other thing is, I mean, the mood problem itself is vague on its own. But it does contain certain details that will be useful. So, for instance, when I ask a question and you answer, I would expect you to answer with reference to the mood problem because I'm looking at the mood problem myself and I see it right there. But you know, your answers are not really referring to any documents. So it becomes less. I would say I would pay less attention to it because I don't see it being supported with anything. But of course, in our case, I have it right here before me. So that I think is a tip. So you can just say, if I can take Your Excellency to this, you know, whatever paragraph of the mood problem where it states this, and then you can say that. So that will be helpful if you do get to the next round. What Ryan speaks about posting to, look at us when you're submitting, because if you're not with you, or you can ask, is Your Excellencies with me on this point? Can I start? Can I stop? You know, things like that. So that I think you have to be aware of that, because if you do get to the final round, the judges might not be or the, you know, if they are judges, for instance, like actual judges, they would really do expect something like that. I think that's it when it comes to my feedback. I don't know if you have any questions. Ryan, are you still with Datuk Ma? Are you still with Ma Wing Kwai, or I don't have the right Ryan? I'm not sure.
Oh yes. I'm not with Mawing Kwai anymore. Actually, my partner,
Ah,
she moved. She set up on her own, and I've joined her. So I'm
I
no
see,
longer
I
with Mawing
see.
Kwai. Yes, yes.
I see, I see. Okay, so clearly I have not kept track of people in the profession and where they've moved. Anyway, so I don't know. That's it for my feedback. Just be careful of that. I think generally intonation was okay, but wow, you guys were really reading off it and trying to finish whatever it is that you're saying. So you need to maybe, I want to see you speak. I don't want to see you read. I can do that myself, right? So I think that's it for me. So that's it. I think thanks everybody, and all the best. Yeah.
Thank you,
Thank
everybody.
you, Excellencies.
Thank you, Mr. Sis.
Thank you, everyone. Good job.
Thanks.
Have a good day, everybody.